Good morning, everybody. Welcome, welcome. We'll give you some time to load on into the room. For those of you that I don't know, my name is Andrea Hansen. I am the Executive Director of the Kern Dance Alliance and the Program Director for the KDA Creative Corps. We are so thrilled that so many of you are joining us this morning. Today is webinar number 4 in a series of 6. We'll be talking with our HR and legal experts, giving you free advice to help you along the way as you move through the KDA Creative Corps process. For many of you that have been sitting in on these grant writing webinars, you may be discovering that these aren't your average grant writing webinars. We've been really intentional about not only giving you the tools to be successful grant writers throughout this process, but also providing professional development and mentorship opportunities in areas beyond the actual writing of the grant, which is why we've loaded in our marketing and our PR experts and our legal and our HR. And next week, we'll dive in with our finance team, from our accountants to our bookkeepers to our bank representatives. These webinars are really meant to give you tools to succeed, not just as a potential grantee, but also as a person operating a business or working as an individual artist, creating a business within the realm of the arts. So we're hoping that you're enjoying this process. As I mentioned, my name is Andrea. We're thrilled that you are here. I'm going to go ahead and get us moving in the right direction. Like I said, today is all about webinar number 4, Understanding the Creative Corps HR and Legal Practices. Joining us today are going to be Dr. Juanita Webb, who owns Empowering Solutions. She is our HR expert, as well as Rob Noriega, who is from the Young Wooldridge Law Firm. He's also acting on behalf of the Corps, the KDA Creative Corps, as our legal counsel. We're so delighted that they are here. Before I give the floor to them, just a couple of housekeeping rules. We have Alex in the room as our official ASL translator. So if you're looking for accommodations, go ahead and click that ASL button. She will be there to help you with any assistance you might need. Also, we are recording today's session, and it will be available online on the KDA Creative Corps resource page. Once that's loaded online, it also will be available with Spanish subtitles. We will be having a Q&A and chat session available for you once we get through our presenters. Joel is in the room. He's going to be helping us today moderate those questions. So please start loading your questions into the chat or into the Q&A now. Joel will be collecting those, and he'll be assisting those a little bit later. So without further ado, here is a little bit of a breakdown. Both Dr. Webb and Rob are going to be talking about your business structure and hiring employees. Once we're through that, we'll cruise on into the Q&A and the wrap up. And you probably all already know that today is the deadline for the letter of intent. So if you have questions specifically about your LOI, we are here. Those do close at 11:59 p.m. tonight. Without further ado, it is my esteemed pleasure to introduce to you both Rob and Juanita, professionals that I greatly admire and I'm so happy to be working with. Rob, the floor is yours.
Good morning. My name is Rob Noriega. I'm an attorney with the Young Wooldridge Law Firm based in Bakersfield. My purpose is to help KDA help you. With that being said, I have to give you a disclaimer that follows along with my professional and legal obligations. I can't create an attorney-client relationship with any of you by providing this presentation. I'm legal counsel only for KDA Creative Corps, but I'm providing some generic information that hopefully will be helpful. I can't really answer any questions that will be specific to your situation. I can try and steer you. If through Q&A you have questions, I can steer you to a good resource. But really, if you have problems or issues that relate to your own situation, you should seek out your own legal counsel. I have my loyalty and my professional obligation only to the Creative Corps, but I am happy to assist KDA in providing some guidance to you folks. So the first thing that I want to talk about, the first agenda item that we have is business structure. And so I want to talk about corporations in particular because many grant applicants are going to be corporations. I understand that there are some that may be individuals, but for the most part, I think we're going to be dealing with corporations and in particular, nonprofit corporations. So I want to talk about the business structure of that for a few minutes. It's not particularly interesting, but here it is. There are different levels of governance with nonprofit corporations. One level, I'll call it the highest level, is really optional, and that's called membership. Members would be the nonprofit equivalent to shareholders in a corporation. The shareholders of a corporation, of a for-profit corporation, are the owners of the corporation. Differently, though, with members of a nonprofit corporation, they're not owners. There's nothing to own in a nonprofit corporation. But I'll call them the highest level of governance because their power and their responsibility is to elect the corporation's board of directors. Now, this is an optional level of governance because nonprofit corporations don't have to have members. They can have as their highest level of governance the board of directors itself, which actually would then just elect its own members or members of the board if there's not a membership level of governance. It's strictly optional for each organization. The benefits of having members is it gives you greater outreach into the community to have these volunteers participate with your organization. The downside, if you could call it that, it's just having an extra layer of governance for the board of directors to be dealing with. Then we drop down, we've got members, we've got a board of directors. The board of directors with a nonprofit corporation has to be at least half independent. And, you know, there's legal niceties about independence, but the bottom line is it would have to be people who are not employed or don't have relatives who are employed by the organization. So you have to have a board that's more than half independent. And the board really is going to be the driving force in, you know, overseeing the operations of the nonprofit corporation. And then dropping down one more level of governance, you have the nonprofit corporation's officers, which would include a minimum of a president, a secretary, and a treasurer. And those people would, in all likelihood, be employed by the nonprofit corporation to run the day-to-day operations of the organization. The president's role is obvious, and that's, you know, being primarily responsible for the oversight and the operations of the company. The secretary is responsible for maintaining the corporate books and records, and the treasurer, that's obvious, the treasurer is responsible for the finances of the company. One of the things that an applicant for KDA's grant needs to do is provide a certificate of status from the state of California. I'm going to share my screen in just a minute to walk you through, if you're not already familiar with the process of obtaining that certificate of status for a corporation. So let me get my screen shared. And you should all be seeing a page from the California Secretary of State's website. It's really a good page, a good website dealing with business entities. And if I were to log in, you can see in the upper right corner, there's an option to log in. Then there's even greater access. But I'm not going to do that this morning. This is just the page that any user would see. So I'll click right here on free business search and copies. And that takes me to a page where for free, I can search for business information and even get copies of business records. So here toward the bottom of the screen, you see a search line, and I'm just going to randomly pick Kern Dance and see what comes up. And look, we have here at the bottom, Kern Dance Alliance, which is a nonprofit corporation. So I'll open that up, and it tells me some things about the organization. It gives me mailing addresses. It tells me who the agent for service of process is. I can even get nosy about the corporation and pull up their most recently filed or any of their filed statement of information forms. It's a form that corporations are required to submit every year to the Secretary of State, identifies the principal mailing address, the names and addresses of the officers and directors. And to remain compliant in the state of California as a corporation, you need to have one of these on file every year. Okay, now back to this page. You can see right here, if you're following my cursor, it says request certificate. Now, if I click on that, it's going to say access denied, and that's because I haven't logged in. But if I were to log in, then it would give me the opportunity to request a certificate of status from the Secretary of State. And it used to be you'd have to do it by mail and you'd have to wait days or weeks for that information to come back to you. But now it's all digital. You can put in the request, you can pay $5 with a credit card, and same day you'll get a certificate of status back from the Secretary of State that will inform any interested party on what the status of your corporation is. In other words, whether the corporation is in good standing. So it's a very useful tool. And I understand that KDA has this web address, or at least will have its web address on its resources page. So you can find it there, or you can contact KDA to get this web address to get to this page. So what you can and might want to do is on this search line, put in your own corporation's name, search for it, pull it up, see what comes up. And from there, you'll have the opportunity to request the certificate of status. And, you know, to go through the grant process with this particular grant that KDA offers, you are going to have to show a status in good standing. Let's see, I'm going to take you to a couple of more things. Corporations in the state of California that are nonprofit corporations need to register with the California Attorney General's office. So this is the web page for that, the charities page for the Attorney General. You're following my cursor, you can see this initial registration link. Click on that and it takes you where you need to go in order to register your nonprofit corporation with the California Attorney General's office. And the Attorney General is the state officer who's charged with the responsibility of making sure that nonprofit corporations are raising funds and using funds for proper nonprofit purposes. And then one other thing I want to do in terms of business structure is just guide you to this publication right here. It's the Attorney General's Guide for Charities. And so it provides useful information for California corporations. Here's the table of contents, for example. So I talked about governance with directors and officers. You see here, Chapter 7. If we were to click on that, it would take us to useful information for nonprofit directors and officers. So again, this web link, I think, is being provided or will be provided by KDA for your use. And so I am going to stop sharing because that's the end of my discussion on business structure for corporations and nonprofit corporations. And with that, I'll run it back to the agenda, and Dr. Webb is going to start us off on item number 2.
Great. Well, thanks so much, Rob. I appreciate that. Good education for all of us about the corporate side of it, and getting that business structure set up effectively so we can participate in this process. So probably a good idea if you're participating in this, grab a cup of coffee, sit back, take lots of notes, because there's still lots to come as we talk about now, how do we start to determine whether we can hire contractors or employees. And that's really an important distinction in the state of California. But before we jump there, let me just answer one other question. Please understand that here in California, certain rules or laws, regulations will apply to organizations depending on the number of employees that are in that organization, and even sometimes the industry that they are in. So if you are a nonprofit, certain rules may apply or may not apply depending on your organization and the size of your organization. So it's important to be aware of that. There are some rules in California that apply to all employers. There are other rules that only apply if you've got 50 or 75 employees or more. There are some rules that apply if you have 1 employee or 2 employees. So it's very important to be aware of that and to understand what rules would apply depending on the size of your organization. I know there are probably many of you today who aren't corporations, who are maybe a smaller employer or maybe a sole proprietor. And so understanding how these rules and regulations will apply to you will be important to make sure you're in compliance and can provide the things that are required in order to submit your application for the grant. So one of the biggest questions is, do I have to be an employee or can I hire someone as an independent contractor? And there's really a lot of discussion on this topic. There has been for a number of years. Some of you may remember a few years ago when Prop 22 came about and we all voted on Proposition 22 that was trying to decide whether someone could be an independent contractor like a Uber or Lyft driver or truck drivers if they could. We did vote on that in the state of California, and then the Supreme Court put a hold on that. And so we're still working through that. But in the meantime, we do have some legislation that went into effect that's called AB 5. And this is the law that went into effect that we were trying to vote to change. And again, like I said, the courts have put a hold on that voting. But there are 3 aspects to that law that when we're trying to decide whether someone can be an independent contractor, we need to pay attention to. And it's called the ABC test because it has 3 pieces to the test. And the first one, the A part of it, is that the worker has to be free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. And we're going to talk a little bit later. Rob and I both will share a little bit about contracts, but just be aware, just because you have a contract with someone doesn't make them an independent contractor. And so that's an important distinction. The other
I
thing
warned Juanita that I was going to interrupt her at this point.
Yeah.
Juanita, can I just have my little spiel on this? I see this. I see people try to characterize their contracts every which way, saying, you know, so-and-so is a consultant, so-and-so is not an employee, so-and-so is an independent contractor. They say it in their contracts until they're blue in the face. Those labels aren't going to matter at all. What's really going to matter is going to be the test that Juanita is discussing. So just don't be misled to the belief that you can call someone an independent contractor or a consultant in a contract and that's going to matter, or that's going to make them take on that status. Okay, thanks, Juanita.
That's okay, Rob. And please feel free to jump in anytime. The other thing that I hear many times from clients is, well, I issued a 1099, so they're an independent contractor, right? No, they still have to meet this test. And so that's where you need to really focus to decide, can this person be an independent contractor or do they actually have to be an employee? Just understand that here in the state of California, the law presumes that workers are employees, and you have to be able to prove that, no, they truly are an independent contractor based on this test. So we talked about the A piece of this test. The B part, this is probably the most difficult piece to meet. And this says that the worker performs work that is outside the usual course of the hiring entity's business. So let me see if I can give you an example of what that means. As you know, Rob is an attorney, and let's say they have a big project and they need to bring on some additional attorneys to help just with this one project. Maybe it's only going to last a few months. And so they want to hire those outside attorneys as independent contractors. Well, that's not going to work according to this test, because those workers are not performing work that is outside the usual course of the hiring entity's business. They're still performing legal services, just like Rob would be as an employee of that organization. On the other hand, if his law firm needed to hire a plumber to come in and repair a broken toilet or fixture, that person could be hired as an independent contractor, because typically lawyers aren't very good at repairing plumbing. And so they need to hire, I love getting to pick on attorneys. So they get to hire that plumber to come in and repair that plumbing, and they can hire that plumber as an independent contractor. So hopefully that helps you see some of that distinction as to when someone could be an independent contractor as compared to not. And then the last piece of the ABC test is that the worker that you're using, if you're trying to classify them as an independent contractor, has to be customarily engaged in their own independent established trade or occupation or business of the same nature as the work performed. So going back to that example of the lawyers and the plumbers, a plumber would have their own business established as a plumber, be offering those services to a number of different clients. Whereas that lawyer that Rob was wanting to hire for that short-term project, even though they may have their own business, they are still performing the same course, the same work as the hiring entity, and therefore still would not qualify as an independent contractor. So you have to meet all three of these tests in order to be considered an independent contractor. Now, I don't want to go too far into the law, but even in addition to this, there is here in California some additional regulations. It's called the Borrello test, which has been what was prior to the ABC or AB5, and the ABC test was the kind of the law of the land. And that's what we use to determine whether someone could be an independent contractor. If you go on to the state of California's website, there's a whole list of what qualifies someone as an independent contractor. There's about 21 different characteristics. So it's pretty hard in the state of California unless they are established as their own independent business and they are not performing work that is the same as the hiring entity for someone to be considered an independent contractor. So very important that you look at that you consider that before you make some hiring decisions. The other thing to be aware of, whether you hire an employee or an independent contractor, there are reporting requirements. Even if you hire an independent contractor, you have to fill out a form for the federal government and for the state government indicating that you're using independent contractors. If you're taking notes, the form under the federal requirements, you can find it on the IRS website, is SS, like Sam 8. And under California law, it is a DE, that's Delta Echo 542 is the form under California law. So both of those forms would need to be completed if you are using independent contractors in your business. So make sure you check into that. So let's say you've decided now that you're going to hire an employee. Well, here's where some of the additional reporting requirements come into play, and you will need to pay attention to certain forms and requirements for employees. Most of us know when you're an employee, you need to complete things like a W-4 form to show what withholding you want taken out. If your withholding on the state level is going to be different than your withholding on the federal level as an employee, then you have to fill out a DE-4. That's under the state regulation. So just some of those typical things. But in addition, one of the other forms, and this has been effective since approximately 2012, this is called a notice to employee, and this has to be completed on every non-exempt or hourly employee by the first day that services are performed for the organization. And you, as the employer, will complete this form so that the employee has information about your business, about their wages, about who your workers' comp provider is, and it also includes some information about sick pay eligibility that the employee will have. So as you can see on the screen, this first page of the form asks for their name, their start date, the legal name of the hiring entity, that would be your business, your physical address, all of that information. Down at the bottom, it asks for wage information that has to be provided to the employee, again, by the first day of service. And you need to include on here what their rates of pay are. Their regular rate of, or their rate of pay, and then their overtime rate of pay. And then whether that's based on an hour, a day, is it commission, what kind of changes or what kind of wages you'll be paying them. The other thing to be aware of is that if any of the information on this form changes, you do have to provide a new form to the employee other than rate of pay, as long as those changes in rate of pay show up on their pay stub. So let's look at the second page of this. It talks about workers' comp. So you will have to provide, and we'll talk a little bit further later this morning about insurance, and one of those would be workers' comp. But you will have to provide information about who your insurance carrier is, your policy number, to the employee, so that if they have a work-related injury or illness, they know who to contact. The other piece that is here is the paid sick leave. If you've been an employee, you probably are aware of the requirement that went into effect back in 2015, that in the state of California, employees are now required to be provided certain amounts of paid sick leave when they are employed by an organization. And we can give you some specifics on that, but basically after someone has been employed by you for a minimum of 30 days, then they are required to be provided at least 1 hour of sick leave for every 30 hours that they work. So if this is a part-time employee, you could accrue that. So for every 30 hours that they work, they would get the 1 hour of sick pay. There's a number of different methods you can use to either accrue this or front load it. That's a decision you can make internally, but the employees are eligible to receive that. There's some restrictions. You can say that they have to wait until after 90 days to be able to use any of the sick pay that they are eligible for, and those kinds of things. So that will just be some specifics that you'll need to get clarification on based on your business and the size of your business and the number of hours that your employees are working. Down here at the bottom, it notes, an acknowledgement. Do I have to have the employee sign this? It's not required. This is just required that you provide it to the employee, but it's helpful if you get their signature and you keep a copy and give them a copy. That way, everything is documented as to what information you provided to the employee. And again, just remember, especially if things like your insurance carrier or even the name of your business, maybe you change the name of your business or you get a new physical address for your business, you would have to reissue these forms to the employees so that they had all of the correct information. So more forms that are required. Most of you are aware of the fact that you do have to complete a I-9 form whenever you work for an employer. This is required of every employer in the United States, has to have one of these for every worker that has been with them since November of 1986. So I don't think you'd be hiring anyone that goes back that far, but some of us have been with our businesses that long, so we have these going back that far. But this is required, and it's required for two purposes. Number one, the employee has to demonstrate their legal identity, that they are who they say they are. And secondly, they have to indicate their authority to work in the United States, that they are legally eligible to work within the United States. And so you, as the employer, have an obligation to complete this. The employee fills out the top part of the form, which is just personal information, their name, their address, their social security number, their date of birth. The employee then has to indicate whether or not they are a citizen or some kind of non-resident alien. They will make that selection, and then the employee signs it. This bottom section is if there is someone else helping prepare the form or as a translator for the employee while they're completing the form. But that's the front side, and that's basically done by the employee. Where the employer has responsibility is the second page of the form. The reason it's important to pay attention to this is because there are fines and penalties associated with either an incomplete form or failing to have this form. The rates continue to escalate. Right now, I believe it's at approximately $225 for every line that is not completed correctly, up to a maximum of $2,500 per form. So if one of the agencies that has authority were to come in to audit and you did not have these forms completed, or they were completed incorrectly, there would be fines and penalties associated with that. So really important that you pay attention to some of this detail. And I know it's paperwork and everybody hates to do that, but it is important to get that taken care of up front. So again, the employee has completed the first page. The employer has to complete the second page, filling in information with the documentation that's provided by the employee to show their identity and their employment authorization. And so you'll record information off of those documents. There is a third page to this form that provides the actual list of documents that an employee can use to prove their identity and their employment authorization. So it might be something like a US passport. That would give us both their identity and their authorization to work. Or it may be their California driver's license and maybe their social security card. Those would be forms of identification that could be used for you to verify both their identity and their employment authorization. Where we usually see the most errors on these forms is this section at the bottom. And that's the certification by the employer that they have actually observed these documents that they've been provided by the employee, and then completing this information. This form where you see my cursor at right now is asking for the employee's first day of employment, putting the date there. Then at the bottom, this next section is asking for the employer to sign it and acknowledge who saw the documents. But this other date where it says today's date has to be within 3 days of their date of employment. And if not, that becomes an automatic $2,500 error if one of the agencies comes in and audits your forms. Okay, that's the maximum fine is associated if this form is not completed within those 3 days. So again, just very important to be aware of that. Make sure you're handling all of this paperwork effectively and paying attention to it. There is a Spanish form. Just please be aware, you cannot use the Spanish form in the continental United States. Don't know why. They won't let you do that. You can use it for translation purposes. So you could have the Spanish form laying next to the English form, but even someone who speaks Spanish or only reads Spanish still has to complete the English form. The Spanish form is only allowable to be used in Puerto Rico. That's our government for you. Okay, so just be aware of that. Please don't get yourself into trouble by using the Spanish form. Also on this, you'll notice there's an expiration date up here. It says October 31st of 2022. We're still waiting on the updated form. They are making changes to this form. So please make sure before you complete the form that you get the most current version for the employees that you're onboarding so that you have the necessary information. Another form that needs to be provided to the state, I didn't put up a copy of it on the PowerPoint, but it's called a DE-34. And what that form is, providing information to the state about who you are hiring as an employee. That form is due within 20 days of hire, and it just reports their name, their social security number, their address, so that the state, if they need to, can follow up with employees to locate them when there needs to be child support payments or those kinds of things. It was called the Deadbeat Dad Law. It went into effect many years ago, and it required that you provide that information to the state. Just one point of clarification as well. If you're going to be hiring employees that are underage, they are minors, and maybe that's part of the creative process, and you need to be hiring individuals who are under 18 or have not yet graduated from high school, please be aware that a work permit is required. They will have to get that completed by their parents, and the school district where they attend school also has to complete a portion of that form. Again, there are fines and penalties associated if you don't have a work permit, or if you are violating the requirements based on the age of the employee. Please go on, just Google work permits in California, and it will give you a whole listing of how many hours certain aged employees can work, what days they can work, whether they can work during school days or they can only work on weekends. There's some very specific requirements when it comes to underage employees. And again, there are fines and penalties, so make sure you pay attention to those requirements as well. Also for employees, I'm sure if you're in a business, you've already seen these posters that are, typically on the bulletin board somewhere in the organization, and everybody never pays any attention to them. Well, those are required. And if you're going to be an employer, you will have to provide those provide those posters for your employees to have access to. Excuse me, the requirement is that they be in a conspicuous location, which basically means, don't put them on the back of a door and then leave the door propped open so nobody can find them. So if you put them somewhere where they can be seen, usually, near where they pick up their paychecks or someplace near the entrance so that when they come into your facility, they can be seen. But there are a number of posters that are required, some under federal law, some under California law, and now even under many local ordinances, there are posting requirements for those local ordinances as well. So just be aware of those. There's a number of them as far as what's required to be posted. Please, many times I know companies order, and you can, again, Google this online, and there will be companies that will offer, oh, we have an all-in-one. This is all you need. So buy this from us and post it and you're good. That's nice and that's helpful, but it's not all complete. There are additional posters that need to be required or that are required to be posted in addition to what's on that all-in-one. The first one that is typically not included is your Industrial Welfare Commission wage order. Those are here in the state of California. There are 17 different wage orders, and you will need to determine which one is applicable to your business. If you go on to the Department of Industrial Relations website there, and you just put in the search bar wage orders, it will bring up the list of all 17 wage orders so that you can look at them. There's also a publication that will pop up that says which wage order applies. You can click on that. You can find out which wage order would apply to your business. But if you were to order that, let me back up. The second piece that is typically not included on those all-in-one posters that you receive is the Form 300A that is required to be posted each year from February 1st through April 30th if you have 11 or more employees. And that's an OSHA form that recaps if you've had any industrial injuries during the past year. So again, those two are not included. You would need to make sure that you added those if those apply to your business. The other thing is when you order that all-in-one poster and they come and you think, great, I got everything I need, and you go and stick it up on the wall, that's wonderful. But there's a lot of blank lines on there that need to be filled in with your company's specific information. Things like, when are your paydays? Who does an employee call if they've had an industrial injury or illness? So your workers' comp information, there's information that you need to complete on the form before you post that. So pay attention to that as well. Again, depending on your location, you may have some local ordinances as well as the state and federal requirements that need to be posted. Like I mentioned, there are some intermittent timeframes, the February 1st through April 30th for the OSHA 100. Usually these posters will need to be updated annually, although sometimes they may get mid-year. There may be notice that there's been new regulations or new requirements, and those need to be posted. If you have a large portion, I believe it's 10% of your workforce that speaks a second language, then you need to post those posters in that second language as well. And so those are typically available. So now we've got the employees working and we've got our posters posted. We've given them the necessary notice to employee. They filled out their I-9. There's lots of other required pamphlets that you need to give them when they're hired. There's a sexual harassment pamphlet. There's a workers' comp pamphlet. There's a paid family leave pamphlet. All of these are available on the state's website, so you can get those there. And I'm happy, Andrea, to give you all of these website addresses that you can then post on the KDA website. So they'll have all of that. I can give you that after the seminar. And that way you'll be able to have those, and then they'll be able to just click on those links to get those. But now that you've got the employee working, one of the other responsibilities that the employer has is to determine what the classification is of this employee. Are they going to be an exempt employee, meaning that they're paid a salary and they're performing certain functions within the business? Or are they an hourly employee and they're eligible for overtime? That's a very important distinction. There's lots of reasons that we have to make sure we get the correct classification. Please be aware that just because you say, well, I'm going to pay this person a salary, that doesn't make them an exempt employee. Just like saying, oh, I'm going to give somebody a 1099, that doesn't make them an independent contractor. Just because you pay someone a salary doesn't mean that they are exempt from overtime. The law presumes that every employee is non-exempt, meaning they're eligible for overtime, unless you can demonstrate that based on the functions of the job that they perform, that they should be exempt from overtime. And what that typically means then is that you're paying them for the job that they do. Doesn't matter how many hours they work in a week. They could work 50 or 60 hours and not be paid overtime. They could work 20 hours and they would still be paid that same rate of pay. But again, it depends on the functions of the job, not the fact that you just want to make them an exempt employee. So we have to very carefully look at what those exemptions are. Typically within the state of California, there's 3 main exemptions. The first is the executive exemption. The second is the professional exemption. And the third is the administrative exemption. The executive exemption basically is someone who's in the management of the organization that supervises a minimum of 2 full-time employees and is performing in work that requires independent judgment and decision-making and discretion, those kinds of things on a regular basis. The other requirement to be an exempt employee is that your salary that you're paid has to be a minimum of 2 times minimum wage for a full-time employee. So knowing that minimum wage for everybody in the state of California now, as of January 1st, is $15.50, would mean that an exempt employee has to be paid a minimum of $31 per hour for a full-time employee. And I think if you calculate that out, that comes out to something like $64,480 for the year. So all of those are requirements for being exempt. I would encourage you to make sure you classify employees correctly. Again, there are issues if you don't, things like having to go back and pay that person for back overtime if you incorrectly classified them and they should have been receiving overtime. There would be fines and penalties because of that as well. And again, as it says here, it's not determined by their job title. It's not determined by, gee, I'm going to pay them a salary. Doesn't matter how many hours they're working, right? Again, that doesn't qualify them to be exempt. It's all about what the functions are that they're performing in the business. Now, under the professional exemption, there may be some possibilities if they're working full-time and performing full-time functions for you, that based on the artistic or creative nature, possibly there might be some exemption opportunity there. But you'll need to review that and determine if that is correct or not. Where you would find that information is that Industrial Welfare Commission wage order that I mentioned earlier, that you need to go on and find out which one of those 17 wage orders applies to your business. All of those exemptions are explained in that wage order. So one of the reasons it's so important to classify them appropriately is because of overtime. Like I said, the law presumes that every employee is non-exempt and is eligible for overtime. And so you want to make sure that you've correctly classified them. So if you do owe an employee overtime, you are correctly paying that. And just a real quick recap on overtime: anything over 8 hours in a day, anything is considered overtime at 1.5 times their regular rate of pay. And then anything over 12 hours is considered double time. Overtime would also apply if they worked 7 days in a work week. And so again, just lots of legal things here that we need, we need to pay attention to and be aware of. So keep that in mind. There's also, especially if you are going to be using an hourly employee, there's something that's called split shift premium. If you are using an hourly employee and you're having them work 2 shifts within the same day. So let's say, let me see if I can give you an example. A typical example would be like a restaurant worker. You ask them to come in from, 6 a.m. to 9 a.m. To help with the morning breakfast crowd. And then you ask them to come back from 4 p.m. to 6 p.m. to help with the dinner crowd. Because there is more than a 1-hour break between their shifts, you have the potential to owe them what's called a split shift premium. And so if you're paying them minimum wage, you would have to pay them for 1 additional hour to cover that split shift time that they were not working. So again, it gets into a complex calculation. If you need help with that, let me know. I can always walk you through that piece as well.
Hey, Juanita, is this a
Yes.
good time for me to interject just for a moment to talk about
Perfect.
the California Labor Commissioner?
Oh, perfect. Yes, please do.
Okay. This is really dangerous. This is why the distinction between exempt and non-exempt can really play a big role. Let's say you're treating an employee as exempt when the person is really non-exempt. That person could go to a state agency. In our case, it'd be the California Labor Commissioner, which is part of the Department of Industrial Relations, and claim to that agency that they're entitled to overtime pay and they haven't been receiving it. And if they truly are non-exempt, then that would be true, that they're entitled to overtime pay and they haven't received it from the employer. But the employer's thinking is, well, you're exempt, so you're not entitled to overtime pay. So a lot is going to ride on who's right on whether the employee is exempt or non-exempt. But the California Labor Commissioner may accept the employee's point of view on that, or advocate for that, and take the position that the employee is non-exempt and therefore entitled to all of this overtime that has not been paid. So that the employee is free to file a complaint with that state agency, and the state agency will process that complaint, which could include some investigation. That would include asking the employer to provide documentation and to answer written questions with written answers, and ultimately to even participate in an evidentiary hearing to determine whether or not the employee is exempt or non-exempt. And if the employee truly is non-exempt, then how much money is the employee entitled to for unpaid overtime? And the numbers can get really high. They can add up. You can go back quite a period of time in calculating the number of unpaid overtime hours, and there's interest on top of that. There's penalties on top of that. I think it's been a while since I've handled one of those, but I think the penalty consists of something like the value of the last 30 days of wages.
Yep, you're absolutely correct.
Nodding.
Yep.
So I'm not outdated on that. So those numbers can add up to be pretty big. So that's why it's so important to, as an employer, when you make that distinction between exempt and non-exempt, make extra sure that you're right, because the cost of being wrong can be really painful. I'll just make one other anecdotal observation. Roughly 60 years ago, when my dad started a business, my mom handled the payroll by handwriting out paper checks and calculating the appropriate deductions. And sadly to say, that just doesn't work anymore. It would scare the heck out of me to have to write paychecks and make sure that they were accurate. So the bottom line is, just as your business or future business may need a lawyer or may need an HR consultant, it for sure is going to need a bookkeeper or a payroll consultant to assist with issuing paychecks that are compliant. Okay, that's my interruption.
That's
Sorry.
okay. And that was a perfect segue, Rob, because the very next topic I had to talk about was pay stubs. Because if there is that situation where that you get called into a hearing and they want evidence, they're going to be looking at your pay stubs as well. And there are a number of requirements for what is included on the pay stub. And again, fines and penalties if it's not done correctly. What we have seen, and this is going to kind of lead into the next topic where we talk about harassment and discrimination, but when an employee goes in and files a harassment claim and they go to an attorney and the attorney says, well, and, did you ever miss a break? Or did you ever have, an issue with your pay stub? Let me see your pay stub. And typically some of those, ambulance chaser type attorneys will be looking for a pay stub violation because they know that if it affected you, one employee that's filing the claim, likely it may have affected all the other employees in that organization, and now it becomes a class action situation. So very important to make sure your pay stubs are accurate as well and include all of the necessary information. There's like 9 or 10 different things that are required, all of the different rates of pay, how many hours they worked, how much of it was overtime, their sick pay, their vacation, their any holiday pay, those kinds of things all have to be itemized. You have to have some kind of an identification number for the employee, even if it's the last 4 digits of their social security number. And you have to have the accurate business name and address on that pay stub as well. And so that's a big issue. I've had clients who've had concerns with that, where they had the address of the facility where the employee was working, but that wasn't the legal address of the business. And it was the legal address of the business that should have been on the pay stubs. And so that's been a concern or an issue. Go ahead.
One thing to watch out for is just make sure that your record keeping on this is good. I mean, not only do your pay stubs have to be complete and accurate, but you've got to have a good timekeeping system to record how many hours an employee works. I talked a few minutes ago about these labor commission hearings. You may find yourself in one of those hearings where there's, a dispute over how many hours someone worked, whether or not they worked more than 8 hours in a day. And the employer there's going to be a high expectation of the employer's evidence in that kind of hearing. The pay stubs and the time records and all of that. I've seen situations where the employee's evidence is merely just a pencil written note on the calendar that hangs in their kitchen on how many hours they were at work that day, or keeping their own personal journal that's never shared with the employer or anyone else. And the labor commissioner is going to accept that kind of evidence. So the employer, for its own protection, is going to have to do a very good job of record keeping with respect to hours, and be in a position to refute an employee who shows up with his or her kitchen calendar with pencil marks on it.
Yeah.
And a lot of deference is given to the employee and with the information the employee has.
Yeah.
So,
And I would echo that completely, Rob, is that what I have seen as well is those kinds of situations. And the labor commissioner does tend to favor, information that's provided by the employee when there aren't good records that have been maintained by the employer. So really important that we keep those good records. So just two other comments before we jump into the harassment area. Please be aware of like holidays and vacation time, or PTO, whatever you want to call it. Holidays and vacation are not required under the state of California regulations. That's completely a decision that the employer gets to make if they want to offer those benefits to an employee. If you do, however, offer those benefits to an employee, then you do have to follow the rules and the regulations about like vacation pay and how you accrue that, or how you maintain that, how you pay that out at the time of termination when the employee leaves. So all of that is very important if you choose to offer that kind of benefit to your employees. And then also just be aware for your own organization of the record keeping requirements when it comes to OSHA, the Occupational Safety and Health Act. There is a version here in California called Cal OSHA. And so if there is an injury that one of your employees incurs, you do need to make sure you're giving them a form within 24 hours of being injured, or notifying you that they've had an injury or an accident. Please make sure you give them that form. It's called a DWC1 form. So please make sure you have those available to provide to your employees if they need to.
Juanita, can I chime in on that?
Please do. Yes.
Okay, I want to give your voice a rest every once in a while.
Thank you.
Okay, so on those Cal OSHA reports, here's something to watch out for. And you know, to me, it really didn't make sense, but unfortunately, it's what the OSHA requirements are.
Mm-hmm.
If an employer is if a business is using an independent contractor, and I think the classic example to take would be a farming operation, and they're using a farm labor contracting organization to provide the laborers to do harvest. Let's say one of the harvest laborers gets hurt on the job, and the farm labor contracting organization rightfully reports that injury to Cal OSHA. The farmer also has to report that to Cal OSHA, or find itself on the wrong end of probably up to a $5,000 penalty for not reporting that. Now, the one thing I learned the hard way is the farmer can delegate its responsibility to report that injury to Cal OSHA to the contractor, such as the farm labor contractor. But there has to be a written understanding that documents that. In the absence of that, then that farmer is obligated to make that report to Cal OSHA, even though its contractor already has done so.
Yeah.
So just there's little niceties that can become problematic.
Yeah, exactly. There's all these little hooks that we may not be aware of that can get us into trouble if we don't have that knowledge, or we aren't accessing legal counsel or HR counsel to give them some support in that area. So one of the other areas that can be an issue or a concern for organizations, and you've probably heard a lot about it. We heard the whole Me Too movement several years ago regarding harassment and discrimination in the workplace. And sometimes it's kind of hard to distinguish between, well, what's harassment as compared to discrimination, and, what applies and what doesn't. So I'm going to share a little cartoon with you. I've used this cartoon for years because I think it's just a great explanation of the difference between harassment and discrimination. So let me put that up there on the screen for you. And as you can see, we have the nice female employee standing here talking to her male boss. And she says to him, "All the other women in the office are suing you for sexual harassment. Since you haven't sexually harassed me, I'm suing you for discrimination." So she was being treated differently than all the other women in the office. And so she's going to sue for discrimination. The other women can all sue for sexual harassment. So just kind of a fun concept, but it helps us to see the difference. Please be aware that as an organization, depending on the number of employees you have an obligation to provide sexual harassment training to all employees and all supervisors within 6 months of being hired. If you have more than five employees or more, you have an obligation to provide this training. There is training available, free training that you can do from the the new California Civil Rights Department website. They have a course that is easily available. You can log in and take it. And again, I'll give Andrea the link for that. And she can put it on the website for you, where you can go in and have your employees take that training. At the end of that training, if they complete it successfully, there is a certificate that they can print out that shows that they successfully completed it. Make sure you keep a copy of that certificate so you can demonstrate that they completed the training. Employees have to take a 1-hour class. Supervisors have to take a class that is 2 hours long. All right. And so there is on the website where you can go to get that training, there are 2 different classes, one for employees and one for supervisors. And it does meet the legal requirements in California. There is also multi-languages available for that training. And so if an employee needs the training in a different language, there are a number of languages available. In fact, when you log in, you select the language first, and then you select the type of class, either employee or supervisor, that you want to take. So be aware of that. Pay attention if your employees are sharing with you that even someone that is a viewer of some artistic performance, and that person was a quote, a customer or, a third party, they're not even an employee, but your employee was being harassed by that person, that puts an obligation on you as the employer to address that issue. That's called third party harassment. And so you need to be aware of that so that all of your employees are protected as well. In California, harassment regulations do apply not only to employees, but to interns. It applies to volunteers as well. So be aware that all of those would be covered under the laws here in California when it comes to harassment and discrimination. The harassment laws apply to all employers here in California. For there to be a claim for discrimination, it does apply to employers with 5 or more employees. So that kind of gives you a distinction there of the size of organization. The other thing to be aware of is there are 17 or 18, there's a new one this year, protected classes. For something to be harassment or discrimination, it does have to apply to a protected class here in California or federally. And I'm just going to read you that list. There's a number of them, and we're all aware of most of them. Things like age, race, religion. We know that those are protected, and we can't harass or discriminate employees based on those. But there's a number of them. So let me just read them to you. Age, race, color, religious creed, national origin, sex, disability, whether it's physical or mental, genetic information, ancestry, medical condition, marital status, sexual orientation, gender, gender identity, gender expression, veteran status and military membership, domestic violence victim status. And here in California, we've had an additional one added this year, and that is called reproductive rights decision-making. So all of those are protected categories. And so even if we make a flippant or an unintentional remark about someone's age or someone's religious beliefs, that can be a concern for inappropriate behavior in the work environment when it comes to the harassment and discrimination laws. So we do want to make sure that we're not getting involved in any of that, or that our employees are not being subjected to that, even by people who are outside. individuals. It could be, like I said, someone who's watching a performance. It could be a supplier or a vendor who comes and, works with your staff when you're buying supplies. It could be the UPS man who comes in to your receptionist every day and, he's hitting on her or asking her out on a date constantly. Those kinds of behaviors can be a concern. And as the employer, you are obligated to provide a safe and harassment-free workplace for your employees. And so you want to make sure that you're not getting yourself into any trouble or violating any regulations there when it comes to harassment or discrimination. Rob, I'll let you chime in there and then maybe take over for the rest of the content of today's session.
Yeah, just following up on sexual harassment. One thing to keep in mind as an employer is that sometimes sexually inappropriate conduct, whether it's jokes or showing written materials, becomes a two-way street. Not only is a supervisor, representative of the employer engaging in inappropriate conduct, but an employee, his or herself is. And you may run into situations where the employee who's acting inappropriate actually makes a claim for sexual harassment against the employer. The thing to keep in mind is that in this relationship, the employer, to use a casual term, has to be the adult in the room. If both parties are acting inappropriately, it's really the employer's legal responsibility to control that and to stop any inappropriate conduct, and certainly to choose not to participate in it. So, a typical situation might be mutual flirting between a supervisor and someone who's working under the supervisor. Well, it's not appropriate for either of them to be engaged in that in the workplace, but it's particularly problematic for the employer. The employer is the one who's responsible for controlling the situation, or to use my casual term, to be the adult in the room. The employer is going to feel the brunt of any legal ramifications for the inappropriate workplace.
Yeah.
One other general observation I'll make about discrimination and harassment claims in general, as well as wrongful termination claims, is they're very emotionally charged. It's not like a usual claim or lawsuit between, say, a lender and a borrower. I lent you $25,000 and you didn't pay it back in time. You owe me money. That's contentious and stressful, but it's not emotionally charged like an employment-related case. And because there's, people have to be right and people have to prove the other side is wrong, and there's pride at stake and there are emotions at stake. And so some of these employment cases become very contentious, kind of like divorce cases, fortunately. And that drives them to be litigated on steroids, and they become very expensive and they can last a long time. So prevention is really important. Avoidance of claims is really important in the employment context because the price can be really high for a dispute.
Yeah. Let me just throw one other thing into, Rob, before we jump out of the harassment context. Two things. Number one, the statute of limitations here in California is now 3 years. So an employee maybe, has worked for you and they've left your employment. They can still file a claim up to 3 years later for harassing behavior that occurred. So just be aware of that. It's not just while they're employed by you. They might have left your employment and could still file that claim up to 3 years later. The other thing to be aware of is social media and texting. Even emojis can get an employee into trouble. Please be very careful with that and encourage your employees not to be using those. I had to recently terminate the employment of a young man because he was sending emojis to a female employee. the fruit and vegetable emojis, and I'll leave that to your creative thinking to understand where that's going. But that's what he was doing. And she was very offended by that. And he ended up having his employment terminated. So just be very careful with that. Remind your employees that that would be inappropriate behavior as well. So, Rob.
Yeah, and I'll add on before we leave this subject. If you're going to operate a business, you should use an HR consultant. And one of the things that the HR consultant, such as Juanita, can do for you is to help you prepare an employee handbook, which is going to have your employment policies and procedures. And in general, having all of those policies and procedures is important. There's one in particular that I think is really important when it comes down to harassment, and that is the employer's policies and procedures must place an obligation on the employees to inform the employer of harassment problems. If the employer is going to be charged with the responsibility of dealing with harassment in the workplace, you've got to know about it. And certainly people who are involved in harassing behavior may not be doing that in the presence of a supervisor or someone who's running the business. So as a supervisor or someone who's running the business, you want to know these things. You can't put your head in the sand and figure if you don't know about it, it's not happening.
Right.
Employees have to have that obligation to inform you so that you can deal with it. Because sometimes, depending on who the harasser is, you can be responsible for harassment that you're not even aware of. So you need to make sure that you're protected from that kind of circumstance.
Yeah, good point, Rob. Yeah, the handbook can be very, very beneficial to employers in many of these situations to defend their position, to say, hey, this is the rules that were in place about this situation, and here's what the employee was supposed to do. So good.
Yeah, and the employer, you hate to find yourself in this position, but the employer can make the argument, well, did this harassment even really happen? Because you, the employee, were obligated to say something about it, and you never said anything about it.
Yeah. Good.
What's next on the agenda?
I believe it's the insurance and compliance.
Okay, let's talk about insurance. Insurance is very important for operating a business of any kind. Juanita already went into workers' comp, and that's obviously important. If your employee gets injured, you're legally required to have a mechanism for compensating that employee for missed time from work and medical treatment and expenses, or even loss of employment due to disability resulting from a workplace injury. So workers' comp is obviously important. People ask me, how can I protect my business? Do I need to create some offshore account to hide my assets? And I'm exaggerating, but sometimes there are discussions like that. But really, the most obvious and reasonable solution for protecting your business against claims would be insurance. And there are different kinds of insurance. One is just general comprehensive liability insurance. So if one of your employees through negligence causes an injury to a non-employee, you want to have insurance coverage to cover the liability for that. And the liability could include things like medical expenses and lost wages, and even what we call general damages, which consists of things like pain and suffering and anxiety and depression, sleeplessness, and all of that kind of stuff. So general comprehensive liability insurance is good. You also might be well served to look into having directors and officers insurance. So, if a mistake is made by someone who functions as a director or an officer of your corporation, you can obtain coverage for that. Related to that, there's also, and Juanita could probably speak to this better than I could, but there's also employment practices insurance. So that if a company were sued for wrongful termination or discrimination, there's potential insurance coverage for that.
Yeah.
There's
And
also
that's helpful. The one thing that, just a quick comment, the one thing that your employer practices liability insurance, that protects the company and the owners. Okay. Please be aware that that doesn't cover the employees. So, if you're a supervisor or someone in the organization, you're not going to have that protection by that employer practices liability insurance. That's going to protect the company. Many times employees think, oh, I'm protected because the company has insurance. No, you're not. If you're the one doing the harassing, you would have to have your own insurance. Yeah. So.
Thank you, Juanita.
Yeah.
Good point. There's auto coverage. If your business is going to put people on the road at all, there's always a chance that they're going to get into a car accident, and they're going to have their own personal liability insurance for auto, but you're going to want to have auto insurance as well for the organization, to protect against something that could potentially become catastrophic. You wipe out a doctor who leaves behind a wife and 5 kids. That's going to be a very valuable claim resulting from an auto accident. And then also another kind of insurance for protection would be property insurance, and that wouldn't be related to a claim of liability. It would be related to just protecting your property against damage. If someone were to damage your property, whether it's your building itself, you can have insurance for that to protect against that risk. So I think step number 1 is to identify and select a qualified insurance agent who can advise you based on what kind of business you have and what your business needs are, on what kind of insurances you need and what the costs are. It's, insurance, when you buy it and you don't need it, you feel like you're wasting money because you're spending money on something that hasn't produced anything for you. But when you buy it and you need it, then you feel really smart, due to the fact that you bought something that's protecting you in a bad situation.
Okay.
That's my spiel on insurance. I don't know if you want to add to it, Juanita.
No, I think you're good. I think the only thing we had left on our list, Rob, was any additional comments on compliance and regulations or claims. I think
and compliance and regulations are going to, that's too broad of a subject to really hit on here, other than it's going to depend on what kind of business you're involved in. Whether it's in the arts or whether it's in producing things or providing a service, there's going to be different, particularly in California, there's going to be different regulations and rules that are going to apply. But if I kind of go back to the very beginning of my presentation, when I talked about business entities and corporate structure, the one thing that is so important for an organization that operates in the nonprofit world is to avoid what are called private benefits. That can be very problematic for a nonprofit charitable organization. It can have you stripped of that status. So what I mean by private benefit is, by all means, you want to be careful to not allow any of the corporate assets to provide a benefit to any private person. To use a corporate vehicle, a nonprofit corporate vehicle, for the CEO's wife to use for a trip. I'm just pulling a stupid example off the top of my head, but that's using a corporate asset to benefit someone personally that's not benefiting the social or charitable purpose of the organization. So that's something to watch out for. I was involved in one case a long time ago where a legitimate, qualified charitable organization was involved in a joint venture with a for-profit company. And that in and of itself is legitimate, but the nonprofit corporation part of that joint venture had to be very careful to not allow any of its assets to be used to benefit the for-profit part of that joint venture. So it's kind of splitting hairs, but it's very important. And I think we have a CPA who's involved in a webinar next week.
Right.
The CPA can be very helpful on compliance issues with respect to the nonprofit world, qualifying you for 501c3 status and keeping you in compliance with the IRS's requirements for having that status.
Yeah.
It would be devastating to a nonprofit organization to lose its 501c3 charitable status.
Yeah.
And the most practical effect of that is that your donors won't be able to write off their contributions to your organization as tax deductible. And so that's going to provide a disincentive to your donors to donate to your organization. They can't take that as take those charitable contributions as tax deductions. So you want to keep that 501c3 status in place.
Yeah. Well, I think we've got time for a few questions. Joel, do we have, or Andrew, do we have some questions? I'm going to stop sharing. I think everybody's got the contact information, so I'll turn it back over to you and let you guys take control here.
Yes. Thank you so much, Juanita and Rob. That was so informative over the presentation. We got quite a few questions that came in. I'm going to go ahead and start at the top. So Heidi Bill asked, what is the best way for a nonprofit to seek legal assistance pro bono? Do you have any tips for the listeners today?
I think when you're searching for counsel and you're going to want a business attorney to do that work, when you're searching for counsel, you be upfront about that right at the beginning, that you're looking for someone who's willing and able to provide service either at a reduced cost or at no charge for a nonprofit organization. And, you know, attorneys aren't obligated to do that. And you just need to have the good fortune of finding one who's willing to do that. And not to put myself out there as doing it in all situations. There are times when, you know, I've had a heart for a particular nonprofit organization, and I've done their formation work at no charge. And, you know, one fair trade-off is the attorney can provide the service at no charge, but the client, the prospective organization, would cover the hard costs associated with that, such as filing fees with the state, things like that.
All right, excellent. Well, on to the next question here. Karina Turner asked, would there be any issues if an individual artist operates as an LLC? And I think that's separate from an independent contractor, is what she was referring to.
Yeah, I'm not
If I could
sure.
jump in, let me jump in on that one really quick. So to that question, an individual artist, if they do not have a business entity, has to apply as an individual artist. If you apply as an LLC, then that LLC is going to have the nonprofit status. And then you'll have to provide all of that paperwork within your grant application, including the 501c3, your status of good standing with the state, etc. So it's got to be really clear. You're either the independent artist that can apply for up to $150,000, or you're the organization that can apply to up to $300,000 with the appropriate paperwork backing up your organization.
Good clarification.
Yes. Now, Rob, this question came in from an anonymous attendee today during your first part of your presentation, and they are asking, or they're saying, my nonprofit has an active certificate. I don't see a 990 in their tax documents. However, they have a CTTR1. Does that work?
I'm going to punt on this to the CPAs.
Mhm.
So when you have a CPA presentation next week, hopefully you can get some guidance on that.
All right, so anonymous attendee, tune in next week.
Joel, if I can jump in real quick, I know we're at time, we're at 11:30 to be respectful of everybody's time. We will continue on as long as Rob and Juanita are okay to hang out for another 10 minutes or so. We'll keep
Sure.
answering those questions. In the event you did submit a question and you have to run, we understand. We'll still work to get it answered. Make sure you tune into the recording to get the answer later. Go ahead, Joel.
All right. All right, so on to the next question here. This is from Dixie King. They are asking, we would be paying youth 16 to 24 years old for their participation in the project short term. Sounds like we have to hire them as employees by the ABC test. Does that mean they can apply for unemployment when the project ends?
And
Juanita, you want
I'll
that
jump.
one?
Yeah, I'll jump in on that one. Most likely, yes. And as the employer, you're going to be paying into unemployment, part of the tax obligations that you will have as an employer. And so, yes, that employee potentially will be able to apply. It will be up to the state to decide whether they're eligible, but they would have the opportunity to apply for that unemployment once the contract or the assignment ended.
Excellent. All right. Well, Amy had quite a few questions throughout the presentation today. Her first question was, if one is an independent artist, do the ABC test apply for outside contracted work needed by the artist?
Okay, interesting question. So the artist themselves is a sole proprietor, if I'm understanding correctly. And then they are going to outsource some of the work to someone else. Am I understanding that correctly?
I believe so. So, and I
Okay.
did ask people for clarification on the questions.
Okay.
So yeah.
So if they are a sole proprietor and they are outsourcing work to someone else, then they would have to determine whether that person they are outsourcing the work to qualifies as an independent contractor or needs to be an employee. Is that person that they are outsourcing the work to providing the same kind of service that your business as the sole proprietor is providing? That would contradict with that item B of the ABC test, which may cause them to have to be considered then an employee. Rob, anything else you want to add?
Oh, one other theoretical possibility in the big picture is they could be partners.
True, if they were partners, yes. Yeah.
As distinct from employer, employee, or independent contractor.
Yeah.
And if I can add to that, Juanita, I think often what we might be seeing with this potential opportunity is an individual who has never been given this opportunity is saying, wow, I finally get a chance and I'm going to apply for this funding, but I'm just an individual artist. I've only ever operated as an individual artist. I don't have a business. This grant is only for 1 year. How does this work for me if I do get $150,000? What does this mean? Do I have to somehow now create a business? And like, how does that report on my taxes, which we'll talk to the CPA about next week? But what is the legal way for me to operate underneath this grant without maybe having to create a business and all of these extra items that, frankly, I'm not really sure how to even do?
Yeah. Well, and again, that's going to depend on your business structure. Even as a sole proprietor, I mean, you can still hire employees, right? The sole proprietor is just the tax structure basis that you're setting up your business as, but you can still have employees under that sole proprietor. But then it does mean you have to meet all of these requirements as a sole proprietor. Because you now have employees, you have to meet all the regulations that apply to employees.
If you're an individual recipient of $150,000 grant and you don't have any employees, life is going to be simple.
Right.
And you'll speak with the tax advisor about how the grant itself is treated, if at all, tax-wise. And really, your greatest compliance obligation is meeting the requirements of the grantor, KDA, in order to properly be using the grant.
Right. But if you are going to hire someone to assist or do some work on that out of that money that you receive as the grant, now you have the obligation as an employer. So, yeah.
Excellent. And then there's a second part to this question. Is there a flow chart somewhere or that you know of that's available for independent artists to see the different kinds of forms of employment? And could that be provided after the webinar?
I don't have such a flow chart.
Yeah. I don't either. My accountant always gives me this lesson every year when I go, okay, Juanita, you're a sole proprietor over here, but you've got your corporation over here, two different entities. He explains it all to me every year and reminds me. So I would actually ask the accounting group next week to kind of explain the differences, because there is different tax treatment depending on the way you set up your organization.
All right. Thank you.
Mm-hmm.
Next question here from Karina Turner. As explained today, and she's trying to get clarification on this, a filmmaker must hire employees as opposed to independent contractors to provide camera operators, actors, etc. Is this correct?
There is.
Juanita,
Go ahead. I'm going to let you start, Rob. Go ahead.
I think the easy answer is yes.
It is, but there is also an Industrial Welfare Commission wage order that specifically refers to movie making and motion picture and that kind of thing. So they would want to make sure that they went on to the Division of Industrial Relations website, got that copy of the correct wage order to make sure that they're correctly applying the wage order to the staff that they are going to use. But I would agree, yes, more than likely they're going to have to be employees.
All right. Next question here from Holly Arnold. Do payroll taxes go toward the artist pay or admin costs?
Oh, good question.
What day is the accountant?
Yeah. Next week. Yeah. I would say probably most of that, and Andrea, you can obviously respond to this as well, but your payroll costs are going to fall under your, part of the payroll cost is going to come out of the person's pay. So the person is going to pay their own federal withholding and their state withholding. That comes out of the gross pay piece of it. The obligations on the part of the employer to pay things like unemployment, both to the federal and the state, or the state employer training tax and those kinds of things. My understanding would be that could potentially come out of the administrative side. Is that correct, Andrea?
Yeah, you answered it perfectly.
Right. Yeah. So the part that the employee has to pay is going to come out of the gross pay of the employee. The piece that the employer pays aside from that then comes out of the administrative side.
Got it. All right. Next question here. Lauren Vasquez. This is what she wrote. I'm wondering if, as an individual artist applying for this grant, if I will be required to classify the artists that participate in arts programming as employees, if I plan to hire and pay an honorarium to artists to give a one-time talk or do a workshop.
Yeah, that's a little bit similar to a prior question.
Mm-hmm.
I think that's going to depend on a case-by-case basis as to whether the person is going to qualify as an employee or someone who just provides a service to the individual applicant.
Yeah.
Okay. And then if she plans to hold community events and workshops, does she need insurance for the people who attend?
She should, yeah. Or the facility where it's physically conducted should have insurance and may be willing and able to add the participant onto that insurance policy temporarily.
Okay. Now, if she had the event at a public park, could she be held liable for injuries that were sustained at the park? Okay.
Yes. And I'm sure you'd have to go through the Parks Department to get a permit for that as well. And the Parks Department would probably require the person to have insurance for the event.
Yeah, I believe they actually require like evidence of insurance. So you have to provide an insurance certificate to the Parks Department to be able to use that facility.
Perfect. All right. Question here from Elena Finoki. What defines an employee? If you are an independent artist and you hire someone for contract work for hire for a specific task in your project, is that considered an employee?
And I think it goes back again to that analysis is, are they providing services that are consistent with the same kind of service that your business is providing? Then they're typically going to be considered an employee. They would have to meet the ABC test to be considered that independent contractor.
Mm-hmm. Perfect. All right. Heidi Bill asked, does an employer need to report injuries of an independent contractor?
Yes.
And hopefully, if you have independent contractors, they have a certificate of workers' comp insurance that shows you that they're covered by their own workers' comp, but you still have an obligation to report it. Yes.
Excellent. And from an anonymous attendee today, her question is, are we going to speak about hiring temporary versus full-time employees?
Okay, good question. Hiring, whether you decide to hire someone temporary or full-time or part-time, they are still considered an employee. So all of the same rules and regulations apply. It's just that a temporary employee is only hired for a short period of time. That's really the only difference. They are still an employee and all of the same regulations apply. It's just for a shorter period of time. Someone can be a part-time employee as compared to a full-time employee, and all of the same regulations still apply. It's just that the part-time employee is only working fewer hours than the full-time. Just one clarification, and I appreciate the question because I forgot to mention this during the conversation, is that what is classified as full-time in general is up to the employer. You can say someone is full-time if they work 30 or 35 hours a week or 40 hours a week. The only exception to that is if, depending on the size of your organization, you are providing health care benefits, that is required under the Affordable Care Act to, you have to meet the 30-hour designation is considered full-time and therefore would have to provide the health care benefits under the Affordable Care Act. But that's typically when you have 50 or more employees. So that may not apply to many of you, but typically you get to decide what is considered full-time and what is considered part-time. But the rules are all the same, whether they're full-time or part-time. It's just that one's working fewer hours.
Excellent. And I think one more question here before we wrap this up. Can the funds be used as honorariums for participating artists and performers who sign up for grant-specific events and exhibitions?
Legally, it's not an issue, but Andrea, I'll defer to you on your program rules.
Right.
So honorariums can be given to individuals, but I want to caution you on the language you might be using. I want to ensure that everybody's very clear that you cannot sub-grant money based upon your grant. So I'll just give you the structure really quick. The California Arts Council granted money to the KDA Creative Corps. The KDA Creative Corps now sub-grants money to our awardees. The awardees may not sub-grant money from their pot now to others. So I'm just being very cautious about the language you might be using in your narrative. And honorarium is fine, but I will defer to Juanita and Rob on their expertise about what legal ramifications you might incur if you are just going to give somebody an honorarium versus making them an employee or an independent contractor. What could that potentially mean? And how do they cover themselves to protect themselves from anything that might come back to them?
Rob, I'm going to let you start on that and then I'll kind of,
sure.
Yeah, I'm sorry. Yeah.
Well, it's certainly preferable to have someone assist you as a non-employee. So if they're going to, provide some kind of presentation and you pay them an honorarium, I don't think there's any problem there. You just want to make sure that that clearly is a non-employment situation following the ABC test.
Yeah. And again, just making very clear that what services they are performing, is something that would qualify just for an honorarium and not having to be considered an employee. And remember, there is that distinction of when you have to report, and this will be something I'm sure they talk about next week in the accounting segment. There is a threshold of when you have to report those payments to independent contractors. And I believe, don't quote me, but I believe it's $600 when you have to then report on a 1099 that you've paid someone as an independent contractor.
All right, I think that's it.
Joel, thank you so much for moderating. And I just wanted to kind of, let everybody know as you're starting to work towards your budget mindset, all of these things that Rob and Juanita have spoke about, you can build these into your budgets, your insurance, your legal counsel, your HR counsel, admin elements for sure, because the thing that's most important is that, you operate in a safe and practical manner, incorporating all the people that do the things that you don't necessarily do as well. And I spoke about that in webinar number 2, making sure you're folding people into your project management that execute certain skills that maybe you're not as strong in. And that's the point of these webinars, is introducing you to people that do things that I cannot do. So thank you to Rob and Juanita and Joel. You guys are a wealth of information that I don't have. In addition to Alex, I am not an ASL translator, so you are fantastic. I'll give the final floor to Rob and Juanita, and then we'll have a final wrap up.
Well, I just want to say thank you very much. I have to echo Rob's comments from the initial webinar. I have not a creative bone in my body, so I am so excited to see all of the things that are going to come out of these grants and what's going to be offered here in our community, because I always appreciate art. I just don't have any ability to do it on my own. So
that is so true. So
yeah.
it helps me as well as you, Juanita, to feel like we're contributing to the arts by assisting with this, despite the fact that we have no creativity ourselves.
Yeah, this is our small contribution and something to the arts where we can say, gee, I've contributed to the arts.
Yeah, but I just want to thank you all for your attention. If you need to seek out legal advice, I can't tell you that I'd represent you. I may not, but I can at least try to steer you in the right direction.
And the same for HR assistance. Please feel free to reach out. I'll be happy to, try to assist or give you direction of where maybe you could obtain the type of service that you need. So happy to do that.
And
all right, have a good afternoon.
Thank you, Rob. Thank you, Juanita. Thank you, Alex. Thank you, Joel. Tune in for our final 2 webinars next week on Tuesday and Friday. Of course, letter of intents are due tonight by 11:59 p.m. If you wait till midnight, it will be closed. You will not be able to submit. So please don't wait till that last minute. Reach out to Whitney and I if you have questions. I see my phone literally blowing up. Oh, I think I froze. Can you hear me okay?
We can hear you. Yeah, we just don't. There you go.
Okay.
Now you're back.
I see my emails are just blowing up with all kinds of things. So we're going to be working through that as fast as we can for you. We are a small but mighty team. And just thank you, everybody, for your participation. And we'll see you all soon. Have a great day.
Thanks. Bye.
Thank you.